In the end, it's not the years in your life that count. It's the life in your years. Abraham Lincoln. Welcome to Retirement Mentorship, your mentor to getting through retirement. I'm your host, Freeman Lindy, certified financial planner. We've made it. The last step in creating a financial plan, estate planning. We've created a full financial plan to build and preserve wealth. Now let's pass it on to who you want in the way you want to. Estate planning is not just for the wealthy, it's for anyone who wants to control what happens to their assets and their dependents when they pass away. It's coming up on the Retirement Mentorship podcast. First, the 2-minute tune-in, the primary points of the podcast in the first 2 minutes. We're going to look at 4 pieces of estate planning today. First, we're going to look at 5 problems that estate planning avoids. 1, family fights. 2, family burden. 3, government deciding. 4, delays, and 5, excessive fees. Next, we're going to look at asset transfers. How do we pass on all of the money and assets that we've accumulated in the most efficient way possible? Thirdly, we'll look at what I call estate people, the different people you will need to name to fill various roles in your estate plan, and why those are important. And lastly, tying it all together in creating an estate plan. We're looking at basic estate planning, the type of estate planning that everyone will need. There is, of course, advanced estate planning, and we do quite a bit of that in our financial planning practice with people who need it. But that's outside the scope of this episode. If you're trying to do fancy things like disinherit certain children or pass on vast amounts of wealth, you, of course, will want to do some specific estate planning for your specific situation. I'm also not an attorney, and this is not legal advice, but more education around estate planning. Estate law varies a little bit by state, and I'm most familiar with Wisconsin estate law, but the basics and principles apply everywhere. So without further ado, let's get to the last step of creating a financial plan, estate planning. Creating a financial plan, step 6, estate planning. As we mentioned in the 2-minute tune-in, estate planning is not just for the wealthy. It's a common misconception, and a lot of middle-class Americans think it's something that they don't need to do because they aren't wealthy. The other mistake that's often made is people think that estate planning is simply getting a will, and once you have that, you are good to go. That's not all that estate planning is, and it's not just for the wealthy. Estate planning is, in its essence, you deciding what happens to your dependents, your kids, and what happens to your assets and money and wealth and all of that when you pass away. Estate planning is designed, in my opinion, to avoid 5 problems. There are 5 problems that estate planning avoids. Let's look at each one. Number 1, family fights. If you pass away without doing any estate planning, then your family is left to deal with it. They might not always agree on how they should move forward. This comes about in 2 separate domains. 1, your assets. If you have assets to pass on, and you haven't decided exactly how they pass on and put that into writing in the ways that we'll cover in the next section, your family may fight over them. You might think now that your family gets along fine and that they won't fight over your money, but let me tell you, money does weird things to people. People who are completely peaceable and friendly to each other can tear each other to shreds as soon as money is on the line and they think that they are not being treated fairly. Don't put that on your family when you can simply decide and put into writing what you want to have happen and avoid those fights. The other domain of family fights is often with minor children. If you have kids still at home that are dependent on you and something were to happen to you, more often than not, it's both sides of the family that want to step in to take those kids versus a lack of anyone being willing to. Don't make grandmas fight over your kids. You decide whom they stay with and how they will be supported. Estate planning can avoid all of these family fights. The second problem that estate planning avoids is family burden. Again, this can happen in both your assets and your dependents. If you haven't created a plan and put it in writing what you want to have happen to your assets and have it in an organized fashion where people can easily deal with it, you are leaving a tremendous burden to your family to have to deal with everything you have. I've worked with clients who have had someone pass away and leave a absolute mess for them to deal with. And the headache and chore that becomes over the several months of their lives is a burden no one should have to bear. Don't let them try to figure out and unravel everything you have and don't have. Put it in writing, put it in an estate plan, and make it as easy as possible for whoever is left after you pass to clean up your situation. Estate planning avoids family burden. Number 3, estate planning avoids the government deciding for you. If you don't decide many of the pieces of estate planning, that means the government needs to decide. It will go to probate court and a judge will be appointed. And after evaluating all of the evidence, which may include testimony from family members, see family fights, they will decide what happens to your assets or your children or anything else that you didn't bother to plan for. Of course, no one thinks they're going to die. And as it is with life insurance, I think the people who actually plan for this are the ones who don't die unexpectedly. This seems to only happen to people who didn't plan. If you want to all but guarantee that you won't pass away early and that the government won't have to decide what happens to your kids and your money, then you should decide for yourself. Get an estate plan, you plan it, you put it in writing, and avoid the government, which is well known for its ability to handle families and money. Don't let them decide for you. Estate planning avoids the government deciding what happens to your kids and your money. Number 4, estate planning avoids delays. There is a mandatory probate period, which is at least 90 days, at least in the state of Wisconsin, where any of your assets which have hit probate, which we'll get into in a bit, cannot be passed on to your heirs until that is over. And if there are additional claims or family fights or issues with your estate plan, it could go a lot longer. Probate, this delays is anywhere from 90 days to 2 to 3 years, depending on what's going on with your estate. And you can avoid the vast majority of it, or at least have the vast majority of your assets avoid those delays by having an estate plan. Estate planning avoids delays. And lastly, estate planning avoids excessive fees. You cannot die for free in the great United States of America. It will cost you something, but you can decide how much it costs. You can pay the known fees now to get an estate planning and avoid the probate costs and attorney's fees and legal fees of having your estate handled by people after the fact. It is much, much cheaper to do it now than for it to be handled later. An ounce of prevention is worth a pound of cure, and an estate plan is worth tens of thousands of dollars in probate fees later. Get it done now, and your fees will be minimal compared to the excessive fees of letting it go to probate and having the attorneys fight over it and the government decide what ultimately happens. So those are 5 very good reasons. Any one of those would be reason enough for you to do estate planning, but the fact that you can avoid all 5, family fights, family burden, government deciding, delays, and excessive fees by getting this done, are all incentives to get this done. So what is estate planning and how do we do it? The first part that we'll talk about is asset transfer. This is not necessarily the most important part of estate planning. I think if you have minor children, that caring for them is more important than asset transfer. But the asset transfer applies to people in all stages of life, not just those who have minor children. And so we'll talk about that first. When you pass away, your estate, which is everything that you leave, goes into probate. Now, again, I am most familiar with Wisconsin estate law, and it does vary a little bit by state to state. And so if I say things that are not applicable in your state, well, fair enough, I don't know your state laws in particular. But I believe that a lot of these principles are uniform across all the states. But you will definitely want to check with someone who is familiar with your state law to make sure that this is all accurate. But when you pass away, anything that you haven't decided what to do with goes through probate, which we kind of talked about. It's this process of allowing anyone who has claims to your assets, any creditors you have, the ability to get that money back from your estate, from your belongings, before it's passed on to your beneficiaries. So if you owe money to credit cards or loans or anything else, they have an opportunity to come forward and say, hey, they owed me this amount, I want to collect, and they have first right. Anybody that you owe any money to has first right to your money before your kids or anyone else you were trying to send it to. Like I said, minimum 90 days, can stretch out much longer if there are problems with it. Now, one of the most common estate planning tools is the will, the last will and testament, shortened to the will. Most of us know it's important to have a will, and I think we've been conditioned to believe that a will is all that matters. Part of this, I think, is from Hollywood. If you've seen a lot of movies, like Knives Out comes to mind as a recent movie, there's always these dramatic scenes where someone passes away and the attorney calls the family into the office and there's the dramatic reading of the will and someone's ousted and there's all kinds of drama, right? And so we kind of have this idea that a will is what you need and that's all that matters. Get a will done and your estate plan is done. But here's the deal. Wills do not do anything as far as asset transfers go. All a will does is tells the probate court what you want to have happen. It doesn't actually execute any of your wishes. If you simply say in your will, I want everything to go to the kids, your kids don't get jack until probate is over. I love me some good lawyer jokes. Here's one. How can you tell when an attorney is lying? His lips are moving. All joking aside, there are a lot of great attorneys out there who do great estate planning work and really take it seriously and act in the best interest of the client. But I have been told by multiple attorneys that not all of them practice this way. There are many estate planning attorneys, or just attorneys that do a little bit of estate planning on the side, who simply recommend a will, not because it will handle all of the client's estate planning needs, but because it won't. If someone passes away and all they have is a will, then their entire estate is going to go through probate. And most families don't know how to handle probate. And so when a person dies and they find the will and it's written by XYZ firm, they'll go to that firm and say, hey, you wrote the will. We don't understand this. What happens? And the attorney says, hey, good news, they did this will. That means we can direct probate. There's still a lot of work involved, a lot of filing, but good news, we can do all the probate work for you. You don't have to lift a finger. It also won't cost you anything. The estate pays for all of it. And wills are not that expensive to write. They don't make a lot of money off of it. They make more money off the probate cases on the back end. And so they might charge you, $1,000, $2,000 for a will, but then go make $30,000 or $40,000 running your probate case at the end. And so it's great job security for not all, but some attorney outfits. So all a will does is tell the probate courts and the attorneys what you want to have happen. It doesn't execute any of that. That doesn't mean a will is useless. It names some important estate people, which we'll get to in the next section, but it does nothing for asset transfer. What we want is to have your assets transferred legally immediately upon your death. And there's several ways to do this. One is with joint accounts. Anybody who's on a joint account, they automatically get full command of that account when someone passes away. Joints with rights of survivor. That means the survivor has full right to the account if one person goes. Obviously, a lot of married couples will do joint accounts, so if one of them passes away, the other one gets full control. That makes sense. And you technically could do joint accounts with your children as well, although it's not typically recommended because then they have full control over the account. So that is one way to do it, but probably not the way you would pass assets down to the next generation. Another way is to name beneficiaries. You, of course, have heard of this, and there are two main categories that you can add beneficiaries on. One would be any life insurance that you have, whether through your employer, group insurance, or through any personal life insurance policies you may have. Those will pay out immediately when you pass away. After, of course, you file the right paperwork. They'll cut a check directly to the beneficiaries, and it goes immediately. No waiting for probate. You can also put beneficiaries on your retirement accounts. So your 401k, Roth IRA, IRAs, any retirement accounts can also have beneficiaries. And those will then immediately skip probate and go to the beneficiary you named. One super important note here is that beneficiaries supersede your will or any trust documents that are trying to suck money in. And so if your will says, hey, I want all my assets to go to my kids, but your beneficiary still has it going to your ex-wife or your parents or a sibling, it's going to go there. Doesn't matter what your will says. So beneficiaries trump wills every single day of the week. Beneficiaries are a great way to transfer most of your wealth, since a lot of people's wealth will be in retirement accounts, or if you die prematurely and you're young and you have the proper amount of term life insurance, which we discussed in a previous episode, then that will be a sizable amount of money as well. And beneficiaries are a great way to adjust those. And guess what? Unlike wills, where you need to do an amendment and pay the attorney to redo it every time you want to make a change, you can change your beneficiaries as often as you want simply by filing the appropriate forms. You can't, however, put beneficiaries on non-retirement accounts, but there's a solution for that. In most states, not in all, but in most, you can put what's called a transfer on death or a payable on death, a TOD or a POD on non-retirement accounts. And they do exactly what it suggests. When you die on death, it transfers them to whomever you name. It's basically the same thing as a beneficiary, but for non-retirement, non-life insurance accounts. You can even do this on your house. In most states, you can file what's called a transfer on death deed so that your house can also avoid probate and go straight to whomever you name. So with beneficiaries and TODs, you can transfer the vast majority of your assets to your kids or charities, whomever you choose, immediately and avoiding probate. It also avoids family fights because you named it. They can't do anything about it. It's fast. All they need to do is file some forms, so it relieves the burden on your family. It certainly avoids the government deciding. You've already decided on paper, on purpose, what happens. There are no delays. It's instantaneous as soon as you file all the right forms, and it's free to do. And so beneficiaries and TODs is a great way to handle almost all of your asset transfers for the vast majority of people in a cost-efficient way. Most people will have primary beneficiaries on all their accounts already, but many people forget secondary beneficiaries on their accounts. Or maybe they changed it when they had their first kid and haven't changed it since. And guess what? If you had 2 or 3 more kids, even if your will says, hey, we want all the kids to get everything equally, if your gigantic 401k says that the first kid is the only beneficiary, it's just going to go to them. Got to make sure you stay on top of your beneficiaries, including contingent or secondary beneficiaries. The last way to transfer assets that we'll talk about is with trusts. Now, trusts can get very complicated, and so we're not going to get into the weeds on this. But suffice it to say that trusts are a separate legal entity that can own money and assets and that give you some control beyond the grave. Perhaps you want your money to go to your kids, but you want some stipulations on that. For example, if you have minor kids, perhaps you don't want them to get all this money now. You've got, $1 million of life insurance on both you and your spouse, and so if something happened to you, it's $2 million of life insurance plus other assets going to your kids. And if you have 2 kids, maybe you don't want them inheriting $1 million right now. Now, of course, they would be subject to a guardian who would be in control of that money. But the moment they turn 18 or 21, depending on your state, they get all of it. And I don't know about you, but even at 21, I would not have made great decisions with $1 million in cash that came to me all at once. So you can put restrictions on it. And this is a common thing that we recommend often, not through advice, but just through estate planning, that people with minor children get a trust that allows them to control the money for their kids beyond the grave. Again, that can get into a lot of different facets of what trust can and can't do, and that's just going to be beyond the scope of this episode. Talk to an estate planning attorney or an estate planner and see if trusts are right for you and your situation. One thing to note too is that you don't necessarily need to fund the trust, and that's going to be heresy to some people. There are a lot of people out there who rant about doesn't do any good to create a trust and then put nothing in it. As soon as you create one, you should put your house and all your assets and everything in the trust. I disagree. I think that makes it complicated to operate your life when you constantly need to be signing as the trustee of the trust versus just yourself. Instead, what you can do is you can create the trust so it's available and then you can name it as a beneficiary or put a TOD going to the trust on all of your other assets. That way you have the best of both worlds, full control over all your money now without having to work through a trust, but then everything will go in there and you have control of it beyond your natural life. If you have beneficiaries or TODs going to a trust and then from the trust to beneficiaries, all of that will also avoid probate. So in order to avoid probate, to transfer your assets quickly, to avoid family fights, burdens, government deciding delays, and excessive fees on the transfer of your assets, you will want to set up your beneficiaries correctly, have some TODs on some of your other assets, and possibly even create a trust. One last note is it's usually a good idea, at least in my opinion, to not have everything avoid probate, especially if you owe money to anyone. You can't avoid paying them back by sending all your money to your kids immediately. If you do have 100% of your money avoid probate and you owe various people, 60 grand, they can come back after your kids for that in most states. And so it's better to leave enough money to hit probate to pay all those things off than it is to send everything to your children all at once. So something to think about, something to discuss with your estate planner or estate planning attorney. Complete your estate plan, transfer everything that you have worked so hard to build and preserve to your children and charities as efficiently as possible. The next piece of estate planning is to name estate people. And there are several important ones that you're going to want to name here. We'll run through these quickly. Number one would be an executor or personal representative, depending on what state you're in. It's the same thing. This is the person who's going to, for a limited time after you pass away, is going to do all the paperwork that it takes to have you pass away legally. So they'll file the various documents to get a death certificate and then send your death certificate around to various entities and companies to get beneficiaries to be paid out and all the rest. So this is a temporary job, and it should be named someone who has great administrative skills to be able to do this. You can pay them. You can list it in your will for them to get paid if you'd like. I typically recommend that just because it is a lot of work and can take away significantly from their family and or their work. An executor is something you name with your last will and testament. That's why you still need a will, even if you are transferring 95% of your assets outside of it. The other thing that a will is very important for is to name guardians of any minor children that you have. Guardians are the people who will be responsible for raising your kids if you are no longer around to do it. This isn't important anymore if you don't have kids or if your kids are already adults. But if they're still dependent, you absolutely need a will to name a guardian. Don't let your family fight over them or the government decide who your kids are going to go with. So you'll want to name people. And then if you're responsible, you'll also want to make sure that the funding is available to care for those kids as well. Don't give your 6 kids to your brother with no money to take care of them and put that family burden on them. That's not fair. If you have minor kids, you better have the right amount of term insurance to make sure that financially you will always take care of your kids. That's your job as the parent. That's your responsibility. Don't put that burden on someone else. Get the right amount of term insurance. We covered it in episode 19. You can go back and listen to that. Get the right amount and take responsibility for your children financially. However, if you're not around, obviously you cannot care for them anymore physically and emotionally. So you will want to name a guardian to do that. This will want to be someone who has a big heart, maybe more than a big brain, and who will love and care for those kids as if they're your own. Another piece to that then would be to name a trustee of a trust if you're doing that for the care of your kids, where the money is going into a trust and will be paid out to them gradually over time to care for their basic needs now and then staggered delivery later perhaps. So a trustee that you name will be in charge of the money, and they will work with the guardian to make sure that the guardian always has enough money to care for the kids without spending it all on themselves. So those are often 2 different people. If you decide not to do a trust and you just want the guardians, you would also name a conservator, in most states is what it's called, which is still someone who's in charge of the money, but not through a trust, just in general. You can be the same person. The person who's in charge of the kids' well-being and the money could be the same person, but often it's separate people just for conflict of interest, and also it's two separate skill sets. Someone might have both, but more often than not, separate people. So a will name your executor and guardian of your children, and a conservator if you don't have a trust. The trust documents that you create will name a trustee. The other two documents that you'll need is one, a power of attorney for finances. This is if you don't die, but you're unable to make your own financial decisions. Who then is going to be able to step in and make those for you? And is that something you want to give them power of right now, or only in the event that you cannot make those decisions for yourself? And so the way that that's written is important. And lastly, a health directive or advance directive or living will. It's called a lot of different things. I like health directive because it directs what you want for your health. So if you are still alive but cannot make your own health decisions, then what do you want to have happen? And the best ones, I think, are written in two ways. One allows you to make some of the crucial decisions yourself, and then names a power of attorney for health as well. So for example, do you want your mom to have to decide whether or not to pull the plug if you're brain dead? Probably not. You should probably make that decision for yourself. Or do you want your wife or your brother or whomever to have to decide, the different nursing care things, or whether or not they can harvest your organs? You make those decisions for yourself. So the best health directives will be written so that you make a lot of those key decisions, but obviously you can't make every single decision under the sun for yourself. And so you make the key ones, and then you name a power of attorney for healthcare who can then step in and make any additional decisions that need to be made. And so power of attorney for finances and power of attorney for health with a health directive are the other important documents that you'll need. So will, power of attorney for finances, health directive. Those three documents you will for sure need, in addition to maybe a trust. And wrapping it up, what does it take then to create an estate plan? Well, first you'll want to determine who do you want your assets to go to. Split equally among your children is often a default, but perhaps you want to do other things like bless other family members or contribute to charity. And after you have decided who you want your money to go, you'll then want to figure out what's the best way to get it to them. Again, beneficiaries, TODs, a lot of those things are the best ways. Here's a couple of shortcuts for you. If you want to give money to charity, put them on as a partial beneficiary on any IRA accounts that you have, because then you can avoid paying the taxes on those IRAs, and it will go straight to 501c3 charities without paying any taxes. So it's a great way to give more to charities than you would otherwise be able to give to your kids. So it's a great way there. The other pieces, if you want to give specific things to the guardian. So for example, my brother is a guardian of our kids. And rather than writing him in the will as receiving a lump sum to help him, because, if he gets two kids all at once, he probably need a bigger van, maybe add another room to their house or help move to accommodate my kids. We have it written into our life insurance beneficiaries to pay out a lump sum for him to do those things with. If it's income for being an executor or guardian or that type of stuff, that's written in the will, that they get an income off of it, that's taxable as earned income. But if it's a beneficiary of a life insurance policy or a retirement account, it's not income, and therefore will not be taxed in that same way. So there's definitely some strategy there in terms of how you get money to certain people. And so you'll want to probably work with an estate planning attorney, or again, an estate planner as part of an overall financial plan if you don't fully understand all the ways you can do that. So one, in creating estate planning, you'll want to determine who you want your assets to go to. Then you want to create a trust if you're doing that, because a lot of other things will flow through to the trust. Get your will updated or written for the first time to name executor, guardians if applicable. And then get your power of attorney for finances and health also written up. Then when those documents are created, then you will go back and update your beneficiaries to make sure that those are all correct. Often, you'll name your spouse as primary beneficiary if you're married, and then either your kids as secondary, or if you did a trust, name the trust as secondary. even if the trust says it benefits the spouse first, you might as well just make it secondary and send money straight to your spouse right away if she or he outlives you. But then if you both pass away, have it go to the trust, which will then care for your kids or anyone else that you name. So you'll create the documents, the trust, the will, the power of attorneys, and health directive. You'll create those documents first, then you'll update beneficiaries and add TODs, transfer on death forms, to all your various accounts. I also like to create a summary document that summarizes all of it. This is going to be a lot of pages of documents when it's all said and done. And so creating a summary for the executor saying, hey, here's all my assets. Here's all the companies they're at. Here's the basic summary of what I've spelled out in this estate plan. And that way, in 1 to 4 pages, they can get a full idea of what's going on and makes it easy. They don't have to sift through things or go out and try to find accounts, whether they exist or not. They know where everything is and who to talk to about it. If you're working with a financial advisor or financial planner, of course, they should also have a great idea of where all this stuff is, and they could be a great resource to help your executor and your survivors to deal with your estate plan. Again, lowering that family burden or eliminating that family burden with estate planning. And then lastly, you got to tell somebody, right? You can't keep all this a secret. Someone needs to know where these documents are, the originals, to get copies of them. When we do estate planning with our clients, we always keep a copy of all these documents except the health directive. We don't need that because that doesn't pertain to us, but that should be filed with your primary care physician or your primary hospital. File that with them so they have that on file. All the financials we always keep. That way, if someone comes along and says, hey, by the way, I'm the power of attorney for so-and-so, they're incapacitated and we need to make a withdrawal from their accounts. And we can go back and check ours and say, well, according to what we have, you're not the financial power of attorney, so go away. And it kind of helps protect people's money. And then, of course, if something were ever happened to our clients, we know who the executors are, the guardians, and can work closely with them to make sure that everything gets done properly. And so an estate planner can help you kind of give deeper education on all these if this wasn't enough, which obviously is a lot to try to go through in 30 minutes. And so you could work with an estate planner, especially as part of your overall financial planning. If you're doing that with a good certified financial planner, will understand all of this. And then they can not only help you get it done, but also be that someone else who knows. If you're not doing that, then find someone else, a family member, the executor, someone else who understands the stuff that you can tell, hey, this is our estate plan, this is where it is. And it does no good to create this whole estate plan and then die and have no one know where any of the documents are or that it even exists. Then it's basically useless. So someone should know and have a good track on that. In summary then, you will want to create your financial plan. Write a trust if you're doing that route. Do a will, add your power of attorneys and health directives, change your beneficiaries to get all those in alignment and avoid probate. And by doing all these things, you will avoid family fights, family burden, the government deciding what should happen to your kids and your money, delays, and excessive fees by attorneys and other probate fees. It can be a lot of work. A good financial planner or estate planner can help you with it if you like. And it's one of those things that once you get it done, it's done, right? And you won't have to revisit it after major life changes. If someone passes away, you might have to revisit it. If, a death, a divorce, perhaps other major life changes. But otherwise, it's pretty much done. And even if they're written properly, if you're still in the years where you're having additional children, you can write these documents so that it talks about your existing kids and any future kids. You don't have to rewrite your will or your trust every time you have a new child. And so make sure that it's written well to avoid having to redo it every time little things change. You might have to redo it when big, massive things in your life change. But if you're doing it right, you can avoid having to change your entire estate planning by having your beneficiaries do a lot of the heavy lifting, because those can be changed anytime for any reason. Hope this was helpful in this last step of your estate planning. Don't let all the other work you just did on your financial plan go to waste by then having the government decide what happens to all of it. Get your estate planning done as well. It's the last step, and then you're done. If you stuck with us this far, that's a lot of episodes and a lot of information on all the different areas of financial planning. And it can be a lot. It's a complex world, and it can be complex and a lot of hard work to sift through it. But in the end, you should have a simple Didn't say easy, but a simple financial plan for you to follow going forward. So next week, we're going to be looking at how to create that one-page financial plan that summarizes and simplifies all of this work into one page that you can move forward with. And then the week after that, we will look at, if you want help with any of this, who should you be looking for? Because not all financial professionals have the same education or cost the same or any of those things. So we'll give you some good tips on how to find the right kind of professional to help you with these things if you do want help. Those are the next 2 weeks, and then we'll have completed this season on creating a financial plan. If you have any questions on this, feel free to email us at questions@retirementorship.com, or you can call us at 1-855-6-MENTOR, and we'd love to chat with you, or you can leave us a voicemail if we don't pick up. And with any questions that you have, or perhaps you have a specific situation that you want just some, again, I can't give you legal advice, but we would be happy to give you education on different variants that you have or things that you've seen, or provide any clarification on anything we've talked about. Feel free to email or call anytime. Thanks for listening. We will see you Friday for action episodes from today, and have a great week. This podcast is educational only and is not intended to be investment, legal, or tax advice or recommendations, whether direct or incidental. Again, this is not investment advice. Consult your financial, tax, and legal professionals for specific advice related to your specific situation. Never take investment advice from someone who doesn't know you and your specific situation. All opinions expressed in this podcast are the opinions of the speakers expressing them. All performance referenced is historical and is no guarantee of future results. All indices are unmanaged and may not be invested into directly. Retire Mentorship is not affiliated with or controlled by any registered investment advisor, broker-dealer, or other financial services company.